I have some court footage coming out of Kansas. I think probably the Wichita area, maybe Topeka. I'm not sure, but yeah, I've seen this lady before in other court footage things online. This time she has a real life sovereign citizen in her court, and she handles this guy really well. But see how unprepared he is in court. This is ridiculous, just a traffic violation, but he blows it up into more.
State of Kansas versus Tremaine J. Robinson. Jared Regier, Assistant County Attorney appearing for the state. Mr. Robinson, are you here?
I am here representing the name, ma'am.
You know, that's kind of disrespectful to your parents. These soft SIDS, this isn't my name, as if it's some government name. It's a name your parents gave you, dummy. I mean, I don't understand that, you know, what's the big deal about their name? I'm representing, or I'm not that person, I'm the living being, or whatever the hell they say. It's always some stupidity based on their name. It's your name, just deal with it, dumbass. There's no conspiracy based on people's names.
All right, you need to start your video, please. And you are, is it Tremaine or Tremaine?
The name I'm representing is Tremaine.
Tremaine. And how do you pronounce your middle name?
J.
Tremaine J. Robinson.
On and for the record, ma'am, I want to say that I want to give notice to reserve all my rights and inform the court that I'm not here to testify or plead. I'm here to make a special appearance to challenge the jurisdiction only.
They always try to play the jurisdiction game. It never works for them. The jurisdiction is in the area that you are cited, the violation, they have jurisdiction, okay? Whether you're from Canada or you're from Europe, Middle East, wherever, or from right there in the same county you got busted. It really doesn't matter. They have jurisdiction if you're a human being in that county and you're committing a violation. Now, he isn't in there for a crime, it's actually a violation. Traffic violation is not actually a crime, so it's not criminal court. But that's just the whole violation. Just puck. I don't know why they keep using it. It's insanity if you keep using something that never works. Even that guy that killed those people in Wisconsin tried to use jurisdiction. They have jurisdiction. You're just too stupid to hear it, or you've been convinced by one of these gurus that they don't, but they do.
All right, anything else?
Yes, I would like to see evidence of a charging instrument.
Were you not given a copy of the ticket issued by Trooper Collins?
The charging instrument that I am referring to is a sworn affidavit of the client, of the person that I've hurt.
Now, this is a speeding ticket alleging that you did on March 27, 2023 at 8:48 a.m. operate a motor vehicle in Butler County, Kansas at the speed of 92 miles per hour when the posted maximum speed limit was 75 miles per hour. So this would have been out on the Kansas Turnpike, Highway I-35. Now, what else were you wanting to know, sir, as the allegations against you?
I would like to see evidence of the affidavit of the people that I've hurt. This is a victimless crime if there's no one that I've hurt.
I've heard this term victimless crime a few times, not even just from sovereign citizens, but from other people too. It may be a victimless crime, but the speed limits are put there to prevent victims. And so, you know, posted speed limits there, you're driving a vehicle, you're assumed that you're going to follow the traffic laws. And if you're, this is another note, if you're in court for a speeding violation and you're respectful to the judge, and you're calm and you act polite and respectful, you usually get those reduced to a lesser charge. almost every time I've seen in court, I've been in court over speeding before, and I've always had them reduced. Um, you know, so some of them even on a suspended sentence if you don't get another ticket within a certain amount of days, like 60 days, or more, you can have that dropped. Things like that. But when you come out of the gate already being disrespectful and playing the soft Sid stuff, it's not going to work out for you. It's going to work against you.
Well, the victim would be the state of Kansas in that you violated the laws enacted to protect the people of the state of Kansas. But this is not the type of crime which would require or have individual names listed. So your next point, if any?
My next point is, as I stated, ma'am, I'm not here to testify. I'm not here to plead. I would like to see the affidavit with 2 signatures for the person that I've hurt. If I didn't hurt anybody, there's no crime.
All right, well, I'm going to proceed. So again, Mr. Regier, are you ready to proceed?
I am, Your Honor. As a preliminary matter, it would appear that while Mr. Pate was still involved with this case, but before the motion in order to withdraw was filed by counsel in August, the defendant did file a piece of correspondence of some kind. It does appear to include a motion for discovery. However, that particular document would appear to be procedurally deficient. It does not appear to include a certificate of service. The only address listed appeared to be on page 1 involving the defendant, the traffic court clerk at an address both in El Dorado and in Topeka, as well as the office of the Attorney General. Certainly no service on my office, so there is that.
The subpoena was issued July 7, 2023 for Trooper Collins. Then on July 31st came a correspondence from the defendant as referred to by Mr. Regier herein. Looks like it's about 7 typed pages, and as counsel said, it's entitled Challenge for Jurisdiction and addressed to Butler County District Court Clerk, Butler County District Court Clerk, Office of the Attorney General Derek Schmidt. And it mentions subtitles under the following case law. I request case 2023 TR 1193 be dismissed. Talking about municipal court, administrative law in the next paragraph, ministerial offices being incompetent to receive grants of judicial power from legislature, citing a case, looks like 140 California 1, stating that once jurisdiction is challenged, the court cannot proceed. Next paragraph, the law requires proof of jurisdiction to appear. Talking again about an administrative agency and tribunals, judicial tribunals. Alleged personal jurisdiction of the defendant is void. Court has no jurisdiction, no discretion to ignore what is alleged to be lack of jurisdiction. And then it is signed by a signature that I'm not sure I can make it out, but it says Robinson-Tremaine, J, beneficiary.
These sovereign citizens like to jam up the court with these fraudulent paperwork. And as you can see, she's reading one of them off. The FBI calls this paper terrorism because they love to file court filings. Even though they don't feel they're part of the system, they love using the system. A lot of them collect welfare and other things like that, or they work but they don't pay taxes. So, but they don't pay into the system in any way, but they sure like to use the system. They don't believe the courts have jurisdiction over them, but they sure like to file stuff in court and jam up the courts with and the county and the state with all kinds of ridiculous stuff.
The next page talks about a legislative act of constitutionality, substantial harm, right to a trial by jury, all power inherent in the people, legislative assembly. Officer Collins K. issued the ticket summons on the side of the road and did so without an affidavit of complaint approved by the clerk of the court or judge. Quote, I request a certified copy of that complaint from my accuser stating who it injured. Continuing, quote, no bill of attainder or ex post facto law or law impairing the obligation of contract shall ever be passed, end quote. Then he goes on to request this Officer Collins, quote, speed detection device, including model and serial number and year installed, any documents pertaining to the training certification, disciplinary reports of the trooper, tuning fork calibration records, certification records for the device, more information about calibration records, device records. He says the information requested directly relates to reliability and accuracy of evidence against him. So he's wanting proof provided within 21 days, or an immediate dismissal based on Rule 12, which comes from the Federal Rules of Civil Procedure. Under 28 USC 1746, Section 1. And then it is signed declaring or certifying or verifying or stating under penalty of perjury under the laws of the United States of America, executed July 26, 2023. Again, signature, and then in brackets, Robinson, Tremaine, J, without prejudice. Pretty much the same things he's gone over before. Talking about the judicial officer has to cease because of the administrative law, and pretty much standard language that is used by folks who call themselves or are considered sovereign citizens.
The legal system's become very aware of the Sov-Cid movement. Cops, judges, they're all being made aware. Prosecutors are being made aware of this. So they're already countering a lot of their BS, okay? And that's really what it is. It's BS. It's taking things out of context, out of law books and out of the Constitution, even though they consider themselves not part of the America. So how can they be part of the Constitution? You know, they love to quote the Constitution, but technically they're not. They're outside of that, aren't they? It's just whatever is convenient for them. But, you know, the judge said Sov-Cid. Now, they don't call themselves Sov-Citizens anymore. They're American national. But the legal system has now labeled that as sovereign citizens, and it will remain as such. So no matter what they change their title to, once they start using that rhetoric, they're labeled as sovereign citizens.
Revocation of signatures on the final page 7, mentioning that, quote, it is on this date, July 27, 2023, I, Tremaine J. Robinson, it's Tremaine-J, Robinson, in the county of the Seminole of the state of Florida and a zip code, a natural man, attorney in fact, as a living human being who's the beneficiary of Tremaine J. Robinson trademark. Swear that the information in my sworn statement is truthful to the best of my knowledge and understanding. I, Tremaine J. Robinson, beneficiary of Tremaine J. Robinson, revoke my signature on any and all pages of any and all tickets, summonses, contracts, and or agreements signed by the side of the road of the state of Kansas by Officer Collins K., March 27, 23, and then signature authorized representative and attorney in fact. So after that document was filed pro se, apparently by the defendant, Mr. Pate filed a motion to withdraw due to the defendant wanting to proceed pro se. And that was authorized based on the previously referred to 7-page document, it would indicate at the time to the court that Mr. Robinson did want to proceed pro se. So Mr. Pate, attorney, was allowed to withdraw. And so here we are. Now, Mr. Robinson, normally I would be upset that you filed what appears to be in part a motion for discovery and you didn't get that. However, you did not address that document to anybody but Butler County District Court Clerk, Traffic Court, Butler County District Court Traffic Court. You sent one to a PO box in Topeka, and then you sent a copy of it to the Attorney General. But you did not send it to the Butler County Attorney. Therefore, he did not know you were trying to get discovery.
Ma'am, I do have a tracking number that says it was delivered at the Butler attorney.
Okay, well, that's not on file. What you want to present that at this time?
Yeah, someone signed for it yesterday.
So it was signed for yesterday, meaning he put in for the discovery the day before he goes to court. And I don't know how it works. I think it's like 10 to 20 days prior that you have to do that. You have to give them time to put it together. Then you need time to go over it. So, you know, he doesn't know what he's doing. That's why you should never represent yourself in court. Not just because you have the facts and you can prove yourself innocent and all that kind of stuff. Because, well, he does. He wasn't able to. But because you don't know how the procedures work. You don't know when it's time to present your evidence, how to do that, and how to go about doing that, and to get witnesses and all that. A lawyer's gone to school to learn how to do that stuff. These people are laymen at best, and they don't know how the court works. So representing themselves is very, very foolish. I couldn't navigate the legal system. Most people can't. That's why you need a lawyer when you go to court, because they go to college to learn procedures and to learn when things are filed and how to do discovery. If you don't know how to do that stuff, you have no business representing yourself, period. And why these sovereign citizens always want to represent themselves, and it always works out negative towards them, that they come out worse than they would have if they'd just gotten an attorney.
And this document that I'm giving the benefit of, it's a multi-subject document, but this document filed by the defendant that I'm giving the benefit of including what he offers as a motion for discovery was not filed with the clerk until July 31st. So that was after the statutorily required 21 days. And then it was not filed upon the prosecutor who would have, or the witness who would have held any evidence, but rather again on Butler County Clerk in Topeka, Kansas, that to my knowledge doesn't exist, the Butler County Clerk in El Dorado, and Attorney General then Derek Schmidt in Topeka. And that's if it was served, if I take the defendant's benefit of the doubt, that it was saying it was served sometime yesterday before today's 1:30 trial, the court has to decide if that later time was reasonable. And I do not find that it was reasonably served on the county attorney. I am at this point going to say that any last minute motion for discovery is denied and we are prepared to go to trial. Now I've lost you, Mr. Robinson. Are you still somewhere available?
No.
What are you doing there with your computer?
Right now, I was looking for a document, but no, I am not available for trial.
You're not available for trial, but you're right there in court. I mean, and you see what I mean about not filing the papers on time? That's why you need a lawyer.
We're going to proceed with trial. So please put yourself back in front of the camera. Follow the court's order. Are you could be found in contempt. I don't want to do that. Thank you, sir. All right, Mr. Regier, did you tell me you did or did not have any opening argument or opening statements?
Your Honor, I did not specify one way or the other, but the state would waive opening statements at this time. However, if the state would respectfully request leave the court to read from some Kansas case law put down by the Kansas Court of Appeals, which does appear relevant in this matter.
All right, you can document those for the record.
Yes, Your Honor. The state would now respectfully read from State v. Mayor. It's a Kansas it was a Kansas Court of Appeals case, 466 P3D 1236.
Go ahead.
Your Honor, in that particular case, involved a sovereign citizen, where the court noted in the memorandum opinion.
Objection, hearsay. Objection, hearsay.
Case law is not considered hearsay or.
I'm not a sovereign citizen.
It really doesn't matter if you consider yourself a sovereign citizen or not at this point. That is what the court system, the FBI, and many other law enforcement agencies refer to you as. Anybody who acts and uses your kind of rhetoric is considered sov-cids. It's now a legal term for people of that, whether you're American national, American state national, Moorish or whatever, you're considered a sovereign citizen. That is now a legal term for people like you. So it doesn't matter what you consider yourself, you are a sovereign citizen in the judicial system.
All right, he's not a sovereign citizen. Go ahead, Mr. Regier.
Yes, Your Honor. In that case, the Kansas Court of Appeals noted, quote, the defendant thinks the law does not apply to him. He avows that he, unlike other citizens, is sovereign and immune from prosecution. The court went on to address the issue of venue, which the court noted that, quote, venue is generally proper in the county where the crime was committed. I will address that momentarily, as well as referring to KSA 22-2602. Additionally, and perhaps most relevant to this court, the defendant in that case, quote, complains that his objections to the trial court's jurisdiction to prosecute him arise from the claim that he is a sovereign citizen. This is not the first appellate court to deal with such a claim. Another panel of this court used analysis of federal case law to reject a similar claim. And then quoting from Seventh Circuit and Eighth Circuit cases, quote, an individual's belief that his status as a sovereign citizen puts him beyond the jurisdiction of the courts has no conceivable validity in American law. Regardless of an individual's claimed status of descent, be it as a sovereign citizen, a secured party creditor, or a flesh and blood human being, that person is not beyond the jurisdiction of the courts. These theories should be rejected summarily, however they are presented. In referring to an Eighth Circuit Court of Appeals case, United States v. Yagam from 1992, Yagam found similar issues were completely without merit and patently frivolous. It rejected those issues without expending any more of these courts' resources on their discussion. And again, the Supreme Court also referred to a Kansas Supreme Court case from 2019. Quote, our Kansas Supreme Court has recently affirmed the Requena panel. The court held that the claims of sovereign citizenship are ultimately meritless. Thus, if the defendant's arguments are on appeal, rely on his sovereignty claims, we hold they are meritless. And with that, I would respectfully call my first witness to the stand.
All right. I do find that this court has jurisdiction and venue to proceed, and the arguments made by the defendant in the 7-page document referred to previously are summarily dismissed.
All your sovereign citizen stuff is summarily dismissed. It was a big waste of time on everybody's part. You're wasting the court's time with all that BS, and you're wasting everybody involved's time, even your own time. But worst and most important of all, there are other people waiting to go to court today. And you're taking a traffic ticket and turning it into an extra long BS session that didn't even have to be that way. You could have taken care of it right there on the road. You probably one of those things that you had to go to court for, because if you speed over a certain amount, you got to go to court. But nonetheless, it could have been taken care of. You could have been on your way, living your happy life and not worrying about it. But now you've inconvenienced everybody. Good going there, idiot. And what did it gain you? Nothing.
And did you ultimately write the defendant a citation for speeding
Yes, I did.
or an annual redirect? No further questions.
All right, Mr. Robinson, this is your opportunity to cross-examine the trooper. You can question him about his testimony. It's not quite time for you to give your own testimony, so these addresses to the trooper have to be in the form of question. You don't have to question him, but you can. Would you like to?
No,
Now, if you had had a lawyer, your lawyer would have asked a few questions and might have helped lessen the charges against you. But you have nothing because you don't know what you're doing.
All right. Mr. Regier, any further evidence?
None from the state, Your Honor.
The state rests then, Mr. Regier?
The state does so rest, Your Honor.
Mr. Robinson, the state rests. They have presented all the evidence they intend to. Would you like to present any evidence? Again, you don't have to. Your silence will not be used as a sign of guilt. But if you'd like the court to consider your position, I'd be happy to do so.
I don't understand.
But do you want to tell the court your version of what happened?
No,
All right. You don't wish to present any evidence then. Am I understanding you correctly?
the evidence that I tried to present, you won't give due process.
You're so dumb. You are really dumb. For real.
Okay. But do you want to give any testimony about the events leading up to this ticket, March 27, 2023?
No,
All right. Well, I will find the defendant guilty of speeding 92 and a 75. The scheduled fine is $87. Court costs are $108. The total due will be $195. Sir, you do have the right to appeal this proceeding. You can appeal it to the Kansas Court of Appeals. You have up to 14 days to file that notice of appeal. Your appeal bond will be in cash, the same as what your court costs and fines are. That's $195. Can you have this paid, this fine and cost paid in 14 days, or do you need some time?
I'll follow appeal.
Well, you're going to pay for your speeding, just like any one of us. You're not better than any of us. You're not some special sovereign entity, whatever you think you are. You're just an average Joe, just like everybody else. And anybody who drives on the highways and byways has to abide by traffic laws. Traffic laws are there to protect the public and to prevent mayhem, basically. So, you may not like the traffic laws, but you have to abide by them. If you just abide by the traffic laws, you're not going to get the cops to be bothering you. You're not going to be paying a bunch of money. That's probably going to hurt anybody has to pay a bunch of money and fines. Fines are painful. I hate paying fines. That's why I drive the speed limit, or try to. I do have a heavy foot. I'll admit to that. But I try to keep my eye on the speedometer and look out for signs. I was a truck driver, so I naturally look for all the signs when I'm going down the road. But before I was a truck driver, I didn't. So I would not see the speed limit signs sometimes, and that bit me in the ass. But I never played games in court or even with the officer on the side of the road. I was always respectful, and it always worked out better for me. I got less fines. I got oftentimes reduced. On the side of the road, I've drove off with a warning. I've been doing 95 and a 98 or a 75. You could still get a warning for that if you have a good enough story. You just got to know how to talk to cops. You got to know how to talk to a judge. You talk to them respect. And when you're going to try to, plead some trial thing on a speeding ticket, you should at least get a lawyer. I've had a friend in college that, he got speeding tickets all the time, and his dad was rich and get him a lawyer, and he got out of all those speeding tickets. Trying to be your own lawyer when you don't even know procedures and anything like that, it's just stupid. That's all there is to it. Anyway, you guys have a good day and a better tomorrow.